know it already, is Eden Simons-Jones, and as the chair of the Ruskin Law Society, I would like to introduce to you Mr Salter, who has joined us in his capacity as the Oxfordshire Coroner. The Coroner has the role in establishing who the deceased was, how and when and where they came by their death. Where the death is suspected to have been either sudden with unknown causes, violent or unnatural, the coroner decides whether to hold a post-mortem examination and, if necessary, an inquest. For the law students here, this is especially important for the understanding of the legal process prior and during police investigation. I would ask you to keep any questions until the end when Mr Salter will answer any queries. Now I would ask that you give your full attention to Mr Salter and help me by welcoming him to the stage.
Thank you, and also thank you for your brief description of the role of the coroner. That will save me some time a bit later when it comes to that particular slide. I'll just tell you a bit about myself and my role at Oxfordshire and how long I've been there, basically. It's about 3 years almost to the day. I joined as the full-time coroner of Oxfordshire in May 2012. Prior to that, I was a deputy coroner in Devon, where I come from, and also a part-time deputy district judge in the county court. I was also a partner in a law firm in Exeter, and so I was combining my role as a lawyer, solicitor, with these two part-time roles as a coroner and a part-time judge. I qualified as a solicitor in 1997, and as I say, now I'm the full-time coroner of Oxfordshire, although I just about managed to squeeze in 15 days a year, which is the minimum I must do as a deputy district judge, sitting either in London or Oxford or even back at my family home in Devon as well. So that's a bit about me. I'm going to give a talk at a fairly general level, an overview, and hope that that's helpful to you. And also quite happy to answer questions later on. Inquests are one of the main things that people know about coroners, but in fact that's just albeit a high profile, that is a fairly I would say a small part of the work, but it's only part of the work, and I'll tell you about the other work that we do outside of the inquest court. A copy of my slides, no doubt, can be made available if anyone wants them, but I will start with a bit of information about the office of coroner, not to give you a history lesson, but to indicate that coroners have been around for a long time and since Norman times. The Articles of Eyre 1194 described described the role of the coroner as a keeper of the pleas of the crown. It's from the Latin for crown, coronae, where the term coroner comes from. Now, at that stage, the role of the coroner wasn't just about examining sudden death, but it was also to do with recording crimes and the like, but in particular levying fines in the event of sudden death and also confiscating property. So as I say, we've been around for a long time, and just to prove that, this was sent to me soon after I joined the Oxfordshire Coroner's Office by an archivist, and it goes back a long way. I'll tell you the date in a moment, but it's the report of an inquest. I've got the translation from the Latin, and this is what was said on the inquest finding. It happened on Thursday, the eve of the Epiphany of the Lord, in the 29th year of the reign of King Edward, that Robert of Honiton, a clerk, died in the parish of St Michael at the North Gate, Oxford, and was seen the same day by John Osney, the coroner, and had no wound, but the whole of his body was distended and blackened, mostly on the right side. An inquest was afterwards held on the next Monday before the aforesaid coroner, and it then lists all the juries, because at that time all inquests were heard before juries, and all the various names of these jurors are quite interesting. But it goes on to say, and all the aforesaid jurors say on oath that on the Sunday, about the time of Vespers, the aforesaid Robert of Honiton went up the town of the aforesaid church of St Michael, and wanted to help in ringing the bells, and by mischance fell from the tower from a certain hole to the ground on his right side, so that the whole of his body was broken. However, he lingered and lived on until Thursday next. He had all the rights of the church, and all the aforesaid jurists say there is not anyone to blame for his death. So that is, things haven't changed very much, but that is 1301, if you believe it. So that's a very long time ago, and there are still inquest records around, some dating as far as back as then, and even a little bit earlier. So that's a bit about the history. In terms of recent development, up until recently we had the Coroner's Act 1988, and that was the legislation that we worked to. Then we had Dr. Harold Shipman, and I'll remind you about Dr. Shipman in a moment, and the Shipman Inquiry and the Fundamental Review in 2003, which led to a 10-year process leading up to the Coroner's and Justice Act 2009, which, although the 2009 Act only came into force in terms of its provisions and rules and regulations in 2013. So Dr. Harold Shipman, as some of you may recall, was a GP convicted of murdering 15 patients in 2000, probably many more killed than that, but that was what he was convicted of. In the main, these cases were not reported to the coroner, because not all cases are reported to the coroner, and I'll come back to that in a moment. So the doctor, and in this case Dr. Shipman, signed a certificate of the cause of death saying it was a natural cause, no referral to the coroner, which was if you like, there was no double check, no effective double check in place at that time. Now that led to the inquiry, the internal review, and there were two strands actually that came out from the review. First of all, the death certification system, that was reviewed, and recommendations have been made in respect of that, although not implemented yet. And then secondly, the coronial system, there were recommendations for reform and improvement made there as well. Now, the Office of Coroner, appointed and funded by the local authority, but independent, and that independent is important because there is no local authority control of my role and my duties, not least because I could very easily be investigating a death involving the local authority in a care home, a school, or some other social service issue or something of that nature. So totally independent from the local authority, yet funded by the local authority. Coroners have to be solicitors or barristers, have at least 5 years standing. It used to be that they could also be medical practitioners. That changed with the 2009 Act, and no longer can a doctor become a coroner unless they've also got a legal qualification. So that's a change. There are approximately 90 senior coroners in England and Wales. I'm one of them. There are 45 of which are full-time, and the rest are part-time. So not all coroners, as things stand, are actually full-time. But again, the move is to make fewer jurisdictions, larger jurisdictions with whole-time coroners in each one rather than part-time coroners. But that will take some years to achieve. Each coroner has about 3 or 4 assistant coroners who are similarly qualified as solicitors or barristers, but part-time fee paid. They come in when the coroner's off on holiday or busy and do the same role as the coroner, but they're just, as we say, part-time fee paid. Coroner's officers and the police. It used to be the case that coroner's officers were part of the police or former police officers. That's not so much the case now. But investigations are carried out by coroner's officers in conjunction with the police under my direction. That's the way it works. In Oxfordshire, I have 5 coroner's officers, and as I say, they undertake investigations, and they also, importantly, liaise with the family, which is a very important part of their work. I've said 24/7 there because the coroner or an assistant coroner has to be available at all times, at all days, for a part of the work which relates to the coroner's control and responsibility for the dead body. Because if the police want to do a post-mortem or there's perhaps a request for organ donation, then technically it needs to come to the coroner for approval first of all, and that's why there is this out of hours element with that side of things. I'll come back a bit to organ donation, because I think that's one issue which you may be, and the Human Tissue Act that you're looking at in your course, so I'm not sure we've got that far yet. So the Crimes and Justice Act 2009, I've already mentioned it, implemented in July 2013, new rules and regulations. This follows 10 years of consultation, and it's resulted in a significant change in the way the work is done, but the actual work itself, there are still the same basic duties, albeit the way it's done is different. The same basic role and the same legal duty. The idea being, the bottom line, there'll be more effective investigations and inquests. Now this is an important change and an important improvement. In 2012, we had in England and Wales the first appointment of a chief coroner. It's Honour Judge Peter Thornton QC, a judge, not a coroner. That was done on purpose so that there was someone coming in from outside to provide senior leadership. He's still in post for, I think, at least another 18 months or so. And during his tenure, these are the things which he was tasked to actually try and improve and bring in. National leadership, national standards and consistency, more accountability, monitoring of inquests of service personnel, and a service cadre. In Oxfordshire, I have responsibility for military repatriations and inquests, and that stems from the fact that bodies are repatriated from abroad, Iraq, Afghanistan, as well, via Bryce Norton RAF base. And again, as I say, the territorial jurisdiction of the coroner means that I then have jurisdiction, and this was an important thing that was campaigned for, to monitor these inquests so there weren't delays and high-profile cases, to make sure they were dealt with properly. In conjunction with the Chief Coroner, I put together a training programme, and there are now about 10 or 12 coroners nationally who are part of this specialist service cadre to actually deal with military inquests. But all these things, national leadership, standards, consistency, accountability, I should add training as well. There's now mandatory training. These are all very much required and to be welcomed in my view. And it all goes really to the overall aim of putting the family at the centre of the process. They weren't there before so much, but they are now, and to have an open and accountable system. The role of the coroner, I think this is important to understand because it is as you would expect, a legal duty, and it's based on the presence of the body, as I've already mentioned, in the geographic jurisdiction, in my case Oxfordshire. It's already been outlined helpfully, but here we have the statutory duty to investigate if a body is within the coroner's area, and there's reason to suspect that it's violent or a natural death. When it says violent, that doesn't necessarily mean that someone has done violence to someone else. It could be just a fall and an injury, some trauma. The cause of death is unknown, or it's a death in custody. And those are the cases where there's a duty to investigate. Once that duty has been breached, the purpose of the inquest can be outlined in these 4 questions, referred to as statutory questions. They're in the Act. Who the deceased was, and how, when and where the death occurred. And it's an inquisitorial type of court hearing rather than adversarial, so it's the coroner's duty to collate evidence and then to ask the questions and actually make the factual findings in court. One question sometimes is asked, and is what the purpose of coroners are, and there are various answers which people put forward, but these are some of them, in terms of having inquests in particular, or even dealing with the pre-inquest matters, which I'll refer to in a moment. But the purpose of coroners, to give certainty to the bereaved and reassurance to the public, to draw attention to circumstances that may lead to further deaths. Coroners have a duty to also make a recommendation in terms of preventing future deaths where appropriate. I'll come back to that later. to preserve the legal interests of the deceased family and others, to provide accurate medical causes of death, which is helpful for statistics and healthcare provision in the future. And also the common law approach, the common law legal system that we have in England and Wales, as opposed to, say, a civil system in perhaps Europe, France, for example. The common law approach here it's always been the case that death investigation is a worthy object in its own right. That's the approach over the years, stretching all the way back, as they say, to Norman times. And for the bereaved, I think I would say the purpose is to gain certainty. I've already mentioned that, but also acceptance and closure. And that sense of closure is something which is often palpable in the coroner's court. You can actually often see that when they've gone through things, family have gone through things, they've understood things better, had the opportunity to ask questions, maybe ask questions of witnesses. For example, it could be the driver of a vehicle that's been involved in a collision that led to the death of their loved one. Often seeing the person asking questions, getting the answers, you can see that process play out in front of you. Excuse me. Now, the second slide on the role of the coroner. It was Lord Bingham, Master of the Rolls, in the case of Jameson in 1995, who set it out very nicely, I think, to ensure that the relevant facts are fully, fairly and fearlessly investigated. He must ensure the relevant facts are exposed to public scrutiny. He fails in his duty if his investigation is superficial, slipshod or perfunctory. He must set the bounds of the inquiry. He must rule on the procedures to be followed. Again, the emphasis on the questions to be answered and also the inquisitorial nature of the actual hearing. And as I see it, it emphasises that it's a legal duty, a public duty and a public service as well. That's the modern approach. What does that all mean in terms of figures and context? I think the figures do give it some context in terms of what we deal with nationally and locally. These are 2013 figures. The 2014 figures, I think, are due to be published imminently in the next few days or weeks, which will probably be fairly similar to this, at least in terms of these main headline figures. So, in England and Wales, there are just over 500,000 deaths each year. All deaths have to be registered, so that's the number of deaths that there are each year. Well, 2013 in this case. Of that 507,000, oh bless you, of that 207,000, 228,000, so under half, are reported to coroners. Now, of that 228,000, it's 95,000 are result in coroners post-mortems. Now, the majority of these cases, as you can see, the majority of these cases which are reported to coroners result in a natural cause of death being found either by initial investigation or through post-mortem. And it's only 30,000 out of the 228 that go forward to inquest. So that's what I was talking about before when I said there's a lot of work outside the inquest courts that the coroner does. And the initial investigation is very often a paper exercise with inquiries being made at doctors, family, institutions, that kind of thing. And they normally identify that it's a natural cause of death, either with or without a post-mortem examination. And generally speaking, inquests only take place in those cases where it's not a natural cause of death, or despite the inquiries, the actual cause of death is still unknown, and it requires examination and factual findings by the coroner at the inquest itself to determine those things. Let's move on to Oxfordshire. In my jurisdiction, there are approximately 2,400 death reports per annum. This was 2013, but it's similar again this year. And there is this process I've already explained about initial investigation, perhaps a post-mortem, normally identifying a natural cause, and then here at least approximately 270 cases going to inquest. The average time in 2013 for cases from date of report to the coroner, so soon after the death, date of report to the coroner normally within a few days, to the actual inquest nationally is about 6 months. It could be easily 12 or 18 months in a more complex case, and there may be pre-inquest reviews that take place before the actual hearing. Since 2011, repatriations, as I've said before, of service deaths have taken place at Bryce Norton. Then, prior to that, it was Wootton Bassett in Wiltshire, but then prior to 2007, it was Bryce Norton before that. So there's been a long period of time where military repatriations, deaths on active service abroad have come back to Bryce Norton and have been the responsibility of the Oxfordshire coroner. Now, the system that's emerged, certainly also to prevent backlogs building up and delays, because that was really, that did happen at one point and obviously isn't desirable. So the system in place that continues to be in place is that single fatalities, soldiers, servicemen, are initially dealt with at Oxford, but then transferred to the home jurisdiction, so wherever the body goes to for burial or cremation, or indeed where the next of kin is. So single fatalities normally come to Oxford first of all, but then soon after are transferred out. I still retain single fatalities if, for example, it's a non-English or Welsh soldier, serviceman, for example, Gurkhas, various people that also serve in the armed forces. I deal with those cases, and I also importantly retain the multiple fatalities, where more than one person's been killed in one incident. They are still dealt with here. So, for example, as far as Afghanistan is concerned, I dealt with 6 soldiers killed in a Warrior armoured fighting vehicle due to an IED, an explosion in March 2012. 3 killed in a Mastiff vehicle, again due to an IED, in April 2014, and 5 sadly killed in a Lynx helicopter crash in April 14, so only last year, and that inquest is still outstanding and is due to proceed later this year if all goes according to plan. So there's some more figures there to put things in context. I have got some figures for 2014 prior to them being published, and I can say that the national figure, the average time from report of death to the coroner and inquest is still about 6 months, is actually 28 weeks. In Oxfordshire we managed to bring it down a bit, so we're at 26 weeks, just below. And importantly, the national rate of post-mortems, so for cases reported to the coroner, the national percentage rate for post-mortems is 40%, but in Oxfordshire it's only 31%, which is in line with my aim, and indeed the Chief Coroner's expressed aim to reduce the number of post-mortems, because there is a feeling, certainly, and which I share, that we do too many post-mortems, and if there's a way not to do it within the law, then I try not to. Let's move on to the issue of reporting deaths to the coroner. Mostly from the medical profession, GP or hospital doctor, or indeed the police. There's a statutory duty for the doctor to issue an MCCD, a medical certificate of the cause of death, for natural deaths. So the basic position is that the MCCD is a legal document. The doctor needs to certify the death if it's natural, but if it's not natural, then the doctor can't issue the MCCD, and that means the referral is made to the coroner. So as I say, essentially it's deaths reported if they cannot certify as a natural cause, or if the cause is unknown. That's a very simplistic outline, but it's basically how it works in practice. The second slide on this subject of reporting deaths to the coroner. I've listed the main categories, you'll see them there, I won't read them out. That should say if the deceased isn't seen by a doctor during the last illness or within 14 days before the date of death. That's a category of case where there needs to be a report to the coroner. These other ones that you'd expect. I'll say a word about caused or contributed to by medical treatment or during or after an operation. These are often the most difficult cases, and there can be a grey area about whether it's natural or whether it's an unnatural death. And as I say, there can be complex cases, and that applies here in Oxfordshire as well, because John Radcliffe Hospital, for example, is a centre for cardiac and neurosurgery, complicated procedures, risks of death from these operations, and very often it's a case of getting to the bottom of what happened. Was that a recognised complication of the treatment, or was it a life-saving operation that simply failed to save the life, or has something perhaps gone wrong? Can also add actually a couple of other categories which were missed off. Drug or alcohol-related deaths, they're quite a common cause of death which needs to be referred to the coroner. And also another, sadly, common cause of the death is suicide. Those are also dealt with by coroners. Now, from what I've said so far, I think you probably understand that when I say there are three courses of action for a coroner once a case is reported to the coroner. First of all, Form A, pink Form A, as it's called. That's a paper exercise, as it suggests, where the coroner is satisfied that that the cause of death is natural, and that's been determined about a post-mortem or inquest. So that's as I say, a paper exercise. As is a Form B, that's where I determine it's a natural cause, but following a post-mortem examination, but no inquest. Third is where we get to the inquest. The coroner provides a certificate to the Registrar of Birth, Deaths and Marriages to say that it's a case that's going forward to inquest. Post-mortems. If I say a few words about post-mortems, the main reason for a post-mortem is to exclude, in a potentially suspicious case, homicide or to exclude homicide, or in an unnatural death, provide a plausible or accurate cause of death. That's the aim, the evidential purpose. It's part of the overall coroner's investigation and an important part. It's not required in all cases, as I've already indicated, and I've already referred to the 40% national rate, and in Oxfordshire the 31% rate that we have. The permission of the family is not required. It is a legal requirement. That's the way the legislation is. It's a duty to carry out the inquiry. But it is an important power, it's an important decision, and of course it can be a highly sensitive decision and not taken lightly for that reason. There's a decision to be made about whether it's the local NHS hospital pathologist. Now that would be a pathologist normally whose main job is doing tests of tissue, biopsies on the living in the hospital setting, but also do coroner's post-mortems. But not really specialists in the same way as a Home Office forensic pathologist is who will be the pathologist brought in to do a post-mortem in a suspicious case, a murder, a homicide, or something very complex. That's all they do all day long. Well, I say all day long, it takes several hours to do, and so probably certainly not every day, but that's what they do, that's their specialism, to actually provide a very detailed report. And also they're trained to give evidence in court, and you can imagine cross-examination and everything else in the Crown Court. They have skills in terms of dealing with that as well. Now the format of opinion on the cause of death is normally given in a formula, with the immediate cause of death being at the top. So myocardial infarction, for example, and then lower down you would get contributory causes, coronary atheroma, which then led to the myocardial infarction, and then lower down in the formula that's generally used, you would have a condition 2, which is not related in the direct chain of events to the immediate cause of death, but is a underlying disease or comorbidity that that person may have had, which would have also contributed to death, or maybe made them less able to cope with the MI because they had that. So that's how it works. It can get quite involved, but that's essentially it in a nutshell. Histology and toxicology. These are often part of a post-mortem process of investigation to determine the cause of death. Histology is the examination of tissue under a microscope to reveal conditions not evident on examination with the naked eye. Toxicology, normally blood or urine, are tested for alcohol and drugs. Toxicology can also exclude poisoning. Not that that's a very common cause of death, but it can also obviously do that. It can also confirm compliance with medication, and that could be useful, for example, if it's suspected that someone's had a fit, an epileptic fit, have they taken their medication, and it can be a further clue as to what's actually has happened. And it can also identify a cause of death in an otherwise negative post-mortem that may have been carried out. So that's the purpose of histology and toxicology that dovetail in with the pathologist's examination. Now there are, as I said, sensitivities understandably surrounding post-mortems, and religious faiths have their requirements, and that's fully understood, I think, or should be by coroners, and dealt with as sensitively as possible. In the Jewish faith and in Islam, usually the dead are buried within 24 hours. We try and comply wherever possible, and do so most of the time. There are a number of ways that that's achieved. We have an out-of-hours service in terms of signing the required forms, and the coroner's officer being available to facilitate that. I've already mentioned the 24/7 nature of part of the coroner's work. And there can be objections to a traditional invasive post-mortem on a religious basis. And there are circumstances where imaging, MRI or CT scanning instead can actually give the cause of death in a situation where the cause of death isn't otherwise known. And that can be used to good effect, and is increasingly being used more so nowadays. There is a cost implication with that. It's a lot more expensive than a standard post-mortem. Now it's not a great time to be asking local authorities to routinely pay 2 or 3 times the post-mortem rate for MRI and CT scanning, so that isn't something that is commonly in place. There are some schemes in place. There's a scheme that I utilise here where family are prepared to pay the extra cost. They can go down the route of having an MRI or CT scan. Now the trouble with that is a scan doesn't always give you the cause of death, so they could pay I think it's about £500 for that type of examination, scan, still not get the cause of death, and therefore there's still a need for an invasive post-mortem. So that's a difficulty with it. In certain cases it works well, and this is something which is on the up, certainly, and we can come back to that in a moment, and there might be questions about that. Bottom line, however, is that the law applies to everyone. It is the law, and I have a duty, coroners have a duty to determine the cause of death, and if that has to be by the means of a post-mortem, then that has to be the case. Now this is perhaps surprising, that there is actually no statutory definition of what a natural cause of death is. I say it's surprising, but it's fundamental to the issue of whether the coroner has jurisdiction in the case, and yet there's a grey area about what actually is an unnatural death. The Touche case, Laura Touche, it's a sad case going back to 1999 and a Court of Appeal decision in 2001. Now she died following the birth of twins by caesarean section. She'd had severe hypertension due to eclampsia previously. Now, following her death, the evidence was that if her blood pressure had been monitored, as it should have been, she wouldn't have died. The cause of death was a cerebral hemorrhage. Now, is that a natural or unnatural cause of death? That was the issue which went to the court, and the Court of Appeal, as they say. What the family was seeking was a ruling that was an unnatural cause of death, and therefore there should be an inquest. And this is the Court of Appeal's decision on this point. Wholly unexpected deaths, albeit from natural causes, which result from some culpable human failure, they should plainly never have happened, and in that sense are unnatural. And this goes back to what I said earlier on about post-operative deaths, hospital deaths, medical treatment and hospital deaths. These are very difficult cases, and there's often a grey area there about whether it is a death due to the treatment or surgery or the underlying condition which they went into hospital for in the first place, and which made the treatment or surgery necessary. Which is it? As I say, you can soon see how difficult that can be. Opening the inquest, it's now in public. It wasn't before. It's normally only a hearing of a few minutes. Family don't generally attend. The press sometimes attend. It's quite often newsworthy or something which appears in the local paper. But only a hearing of a few moments, a few minutes, within a few days of death normally. And it's to establish formally and judicially that there is jurisdiction to hold an inquest. Importantly, to establish the identity of the deceased. Evidence is received about that initially. That's normally by means of a family or a friend viewing the body and giving a formal identification to the coroner's officer or the police at the time. That's the way that's done. In appropriate cases where necessary, identification can be by means of fingerprint, dental or DNA. After that, the body is released for funeral and there's an issue of the interim death certificate. The main investigation is adjourned for inquiries to be undertaken. And again, this is also new. The coroner should, and I certainly do, at the initial opening, set a final date for the inquest, which is normally 4 or 5 months later, depending on the case. But that's how it works. But that obviously is quite helpful in terms of family knowing the date of the inquest. It's also helpful for people providing witness statements, like clinicians and doctors at the hospital, that they can put this date in their diary 4 or 5 months down the line, and know that they may be required to come to the inquest and give evidence. In terms of the investigations, as I say, the investigation process is well underway once the inquest is opened. Coroner's officers, I have 5, as I think I've mentioned. They're largely office-based, so reliant on the police and other organisations to do the legwork in more in-depth investigations. There's liaison with the hospital trust in terms of obtaining statements from their staff. And other organisations such as the PPO and the IPCC, they go in and carry out investigations in cases such as a death in prison or police custody. I mentioned the fact that there aren't parties at an inquest because it's not an adversarial process, but there are interested persons. That's the phrase that's used in the legislation, and the relevance of being an interested person is that you can have disclosure, an advance copy of the inquest file beforehand. You're obviously notified about the date of the inquest. You have a right to ask questions at the inquest, to be legally represented, and also to request after the inquest access to the evidence, the inquest file. You didn't receive it before, and also a recording of the inquest. All inquests, most were before the new Act, but certainly now they have to be recorded, so recordings are available. Now, interested persons, that's defined in the 2009 Act in section 47. It obviously includes family, close members of the family, but there are also other categories such as the person whose act or omission may have caused or contributed to the death. So anyone that comes within that definition is also an interested person. Could be a hospital trust, for example, the local authority, the driver of the other vehicle in a road traffic collision, and it may be the employer in a workplace fatality, for example. Again, the idea is to put the family at the centre and to give them the information and evidence at an early enough stage to allow them to fully take part in the process. Inquest hearings. Again, this is the part which is more commonly seen or read about, certainly from the reports in the newspaper. Inquest hearings, court hearings can take place normally, most of them between sort of 4 and 6 months after the death. Very often they may be a 30-minute hearing with just the coroner reading 4 or 5 relevant parts from witness statements. And then other inquests obviously could go on and last several days or even several weeks. It just depends on the nature of the case, the complexity and the issues that are raised and the number of witnesses, so it's quite variable. Juries are a fairly infrequent occurrence now in the coroner's court, less than 2%. I think the recent figures which are about to come out will show that it's now less than 1% of inquests take place with the jury, and it's only really the cases where there's a death in custody or a workplace fatality which still require a mandatory jury to be in place for the inquest. Normally it's the coroner who determines the facts and gives the conclusion, the verdict. But obviously in a jury case it's the jury that does that instead, and the coroner just directs them on the law and sums up the evidence. Most common verdicts in 2013, natural causes, 28%. You might wonder why are there so many natural causes conclusions if the whole idea is to weed out the natural causes cases before they come to inquest. Well, this could be the cases where it wasn't known at the time, where it was borderline, and it requires determination by the coroner after hearing evidence. For example, the hospital deaths that I mentioned, where there's a death post-surgery. Is that due to something that's gone wrong, or a recognised complication, or the underlying condition? If it's due to the underlying condition, for example, or just perhaps a recognised complication from the surgery, then arguably that would be natural causes. If it's due to something that's gone wrong during the surgery, then arguably that's more likely to be a verdict, a conclusion of accident. Treatment intended, but not the outcome. So unintentional outcome, accident, that's the way it goes. Accident and misadventure, they're essentially the same thing. I don't tend to use the word misadventure, it's not commonly in use, so I tend to stick with accident. 26% there, suicide 12%, industrial disease 9%, mostly that's asbestos exposure cases and mesothelioma. And not on there, but I should also add drug and alcohol related deaths. They account, I think, for approximately 10% of inquest conclusions. And I think I'm coming to my last slide, so I'm not sure if I gallop through too quickly or what, but certainly there'll be the opportunity for any questions if there are any. But for the moment, a few things I'll just mention here. Regulation 28 of the Coroner's 2000 and 2013 regulations used to be called Rule 43, but now it's Regulation 28 for whatever difference that makes. But basically, it's prevention of future deaths, and it's an important duty. This has been beefed up in the new Act. It used to be a power that the coroner had to make such a report. Now it's a duty that I have. And it's a duty to make a report to a person or organisation that are in a position to review and take action if I think during the course of an inquest there are matters and circumstances which could lead to a future death in similar circumstances. I can make a report, for example, to the Chief Executive of the Hospital Trust, to the Chief Police Officer or whoever, or the Head of Social Services. I can make a report of the details of the inquest and say, not so much actually make a recommendation. It can appear like a recommendation, but it's not meant to be. It's meant to be saying, this is what's happened. I heard evidence from A, B and C. I saw this and that policy. I'm not satisfied that this issue is being picked up and it needs to be reviewed. And then the recipient of the Regulation 28 report from me has 56 days to respond to me. and the Chief Coroner keeps a log, a record of all the Regulation 28 reports and responses that are made. And I think most of them are on the Chief Coroner's website, which is part of the judicial website, I think. What it is, I'm not quite sure what the web address is, but anyway, it's publicly available. So that's an important duty, and one which coroners are encouraged to exercise, and it's something positive which can come out from a sad fatality. I won't talk about Article 2 of the Human Rights Act. I think someone was saying earlier that you've done human rights, complicated business. I think the government are on about not having the Human Rights Act any longer. So we'll see what happens there. But the reason it's there is just to say that in certain circumstances, inquests take on a much broader remit, not just how a person died, but in what circumstances. So it can almost turn into a mini public inquiry looking at systems, systemic failures, background circumstances, that kind of thing. And that particularly applies where there's a potential state involvement in the death. Not so much the police or shooting someone, but it could be, for example, state involvement in the sense that someone dies in state custody. So those are commonly situations where there is an Article 2 expanded remit for the inquest. Organ donation, I think that's something, Human Tissue Act, which you are studying as part of your syllabus. The reason the coroner gets involved, as I said before, is that I have responsibility for bodies within the jurisdiction of Oxfordshire. If it's a case where there's a unnatural cause of death, or the cause of death is unknown, and I have jurisdiction, and before organ donation can take place, it has to be run past my office. Almost invariably, almost always, approval is given, unless it's a case where there are an ongoing criminal investigation and it could interfere with the investigation, or it's an organ that is to be taken, which may be the evidence that I need for the cause of death. But certainly 99% of cases, if there's a request for organ donation made to my office, it's always approved. There's normally a way in which it can be dealt with. Treasure, and that's one area that coroners still deal with. It's a hangover, I suppose, from all those times going back to Norman times and hundreds of years ago. The coroner still determines if a treasure finding is in fact treasure. There's a definition for treasure, and also makes factual findings about who found it, on whose land. Not issues to do with value or who gets it, but just factual findings of the nature I described. One other thing to mention, I'm not sure this would be on your syllabus, but the 2013 Fundamental Review following shipment also importantly dealt with the death certification system, a massive sort of piece of work and recommendations, and it recommended the introduction of medical examiners to deal with the cases really that the coroners weren't dealing with. So the unnatural cause of the death, those were for the coroner, but the natural cause of the death, no one was really scrutinising those sufficiently, and that's why Dr. Shipman was able to write death certificates for them, and there was no other effective scrutiny. So the medical examiner will sit alongside the coroner in a sense and scrutinise on the face of it, the natural cause of the death. But it's a costly exercise. Each area will have to have a medical examiner, or a number of them, with staff. And to cut a long story short, there isn't the funding for it, and it's been put back several years. And whether it will actually ever happen, we'll see. We've got a new government, or at least we have a government in place, and we'll see what attitude is taken to that. I don't imagine it's up the top of the list of things that are going to be done, but we'll wait and see. In the meantime, we have the existing system, which I've described. That's a quick overview, a quick run through, and happy to take any questions. question for me which they don't think of asking, then you can always email and I'll be happy to get back to you. Yes, right. Yes.
First of all, really interesting talk, because I was always under the impression that it's the coroner's cutting over the bodies.
That's right, everyone says that.
No, it's just they use the word interchangeably.
Well, I think what it is in America, isn't it? I think, and even it's confusing in the US, because they have coroners and medical examiners. Some of their coroners are actually doctors that do the post-mortem, so it's confusing, but no, not here.
But yeah, my question is, David Kelly, do you remember that case? And
yes.
There's a big dispute as to whether he actually killed himself or whether he was done in by Tony Blair. So I'm just wondering, do you, as a professional coroner of Oxfordshire, do you have an opinion on that?
What's he going to say?
That is an Oxfordshire case. Yes, it is. Dr. Kelly was from Oxfordshire. It was dealt with by my predecessor. There is provision for, in certain circumstances, if there is a public inquiry into a death, as there was in Dr. Kelly's case, there is a provision whereby if it's dealt with fully in the public inquiry, there's no need for an inquest. It's not something which happens very often, and again, it's not often there are major public inquiries into a person's death. So that was the position here. There wasn't, an inquest was opened, but because of the inquiry that took place, it didn't come back for a full substantive inquest, and that was a decision at the time, and I have no reason to think that was not correct.
So I'm mindful, I think the children have left the room at all one, and I'm sure you're mindful of that as well, perhaps,
yes,
Junior.
Exactly.
My question, are you prepared to take a very general question on suicide?
Yes.
You're comfortable with that?
Yes.
The only question really, and it's quite a straightforward one, is I think, I'm sure that you must find that a very difficult verdict to deliver, possibly almost uniquely difficult. Am I right in thinking that perhaps kindly, compassionate coroners will go that, you know what I'm going to say, don't you? Will they go that little bit extra to try and avoid delivering that verdict?
Could I ask an additional question to that? Because it is a really interesting issue.
I've had experience of that. It's very
okay,
yes.
I mean, I have to, as a lawyer, this is not really from a legal perspective, but literally a reading of the local newspaper's perspective. I've observed over the years that not infrequently there will be an account in the paper, a description of events that really amounts to what you've said, and yet, surprisingly, the verdict is not that.
Yes.
And I must say, I've developed a sort of suspicion over the years that whether it's a hangover of stigma or concern and almost as though, is there a very high bar on the evidence?
That's the issue, actually.
Perhaps you can tell us what this standard of truth is, how you make those decisions.
Because I just had the quick point, I was actually quite surprised at the ratio of misadventure or accident, as you call it, to suicide. The actual suicide percentage I thought was rather high. You know, so I don't know whether that's
sadly, I must say, I am dealing with suicide cases very, very commonly, and it's a large part of the work, and it is extremely sad. I think actually, in terms of the reasons that were given, I mean, that's probably part, I think, hit the nail on the head. Most conclusions in the coroner's court are on the balance of probability. So 50-50, is it more likely than not that someone died as a result of an accident or industrial disease or natural causes? So that's balance of probability. Okay, that's set not very high. There are two conclusions where it's beyond reasonable doubt, the criminal standard. Unlawful killing, which you might expect to be up there, but also suicide. And so therefore, it may well be the case that someone did an act which resulted in their death. But if the coroner is not satisfied that they intended to kill themselves, then you don't return a verdict of suicide. It would perhaps be an open verdict, or you could give a narrative verdict saying was satisfied that person A did an act which resulted in their death, but you would say, but I can't be satisfied on the evidence that they intended to do so. So I think that's a difference.
No,
and I think actually also probably it may be true also that coroners didn't return a verdict when they could avoid doing so. But I don't think there used to be a stigma, didn't there? But I don't think that's. I wouldn't have thought that's still the case nowadays.
Yes, I mean the stigma, but also in some cases the financial implications. If someone's got an insurance policy,
yes,
well, you know, I mean, I mean, I realise that you're a man of law, so that.
Someone did tell me that's changed, and that actually life insurance policies some do actually cover it. So I don't actually know about that.
No,
I can tell you what the chief coroner says,
yes.
And that's that if it is suicide and the evidence shows that it is to the required standard, then the coroner shouldn't turn away from recording it, because it's, again, there is this issue about figures, health planning and provision and all this kind of thing, and that it's quite important to have accurate representations. Sure. And a large part of these figures do come from coroner's
I wasn't
findings.
suggesting anything, but the contrary to that.
But I think the main thing is the standard of proof that's required. It's
Understand.
not just that someone actually did the act, did they intend to take their own life. People do things for cries for help and everything else, and you've got to be satisfied to the required.
I understand. Thank you very much. Thank you.
Yes.
I was wondering, it's quite interesting that you mentioned the change from who can actually become a coroner, and I was wondering, do you think personally the change from coroners previously having a medical background to a legal one is more useful for them to do their job effectively?
Well, actually, I think obviously the ideal scenario would be both to be a doctor and a lawyer, but there aren't too many people. There are some coroners actually that are both doctors and lawyers, but I actually find it quite a struggle sometimes on the medical side of things. So I think there's a place for a team of coroners, and perhaps having, say, a senior coroner who's a lawyer, but within the team having one of the assistant coroners as a doctor. But all the doctors that were coroners prior to the new Act can remain in place, and do remain in place. They're still coroners. What they can't do is move jurisdictions or into other jurisdictions. What they can't do is obtain a new appointment, and other doctors that wanted to become coroners can't, because there are no new appointments. So there are still medical-only coroners, but they're going to be like a dying breed, really. There won't be any new ones. But actually, I think medical knowledge is extremely important, and if we're not going to have medical coroners, then I think lawyer coroners like myself, there's probably a strong case for them having medical, some source of medical expertise available to the coroner. Yes.
Yeah, you mentioned Article 2 of the Human Rights Act,
yes.
and as part of, I think you said it was, as part of your duties, it makes the inquest more wide-ranging, and I'm assuming with that suggests there's cost implications.
Yes, cost implications for
the coroner's office. I was going to go on from that and then say. You mentioned as well that obviously the austerity measures, etc. That we hear a lot about. But, so my question was actually going to be: does the coroner's office feel pressure from the local authority, or whoever holds the purse strings?
Yes, actually, the answer to that is that the coroner's service have an advantage in one sense, because there is a statutory duty on the part of the local authority to fund the coroner's service, which isn't the same for every other service which the local authority funds. So, I can incur cost. It's got to be incurred reasonably and correctly in my duties, and the local authority simply have to pay it. So that's the technical position, the legal position. But in reality, when the purse strings are tight and funds are difficult, as a matter of common sense, you do what you can to be even more efficient. So in effect, although not directly, if there are savings to be made, then you do so. But I have a statutory duty to carry out my role and my function, so I can't let budgetary issues interfere with my core statutory duty of investigation and holding inquests. Because that has to be done as a matter of law. Yes. So let me ask this gentleman. I'm sorry, because I think you put your hand up twice. So I'll come back
just
to
a quick one there. What's the ratio in coroner's office between men and women who's actually got that position of coroner?
Coroners. It's changed a lot in recent years, and the majority of appointments in the last couple of years are vast majority of women. The ratio, I'm guessing now, but I would say is probably something like 60-30 men. 60. That wasn't my strong point.
What, 10%?
Yeah, we won't talk about the other 10%. 70-30 men. Actually, it might now be rapidly approaching 60-40, and I think it's only going to go one way. And so that, as I say, all the appointments, most of them of senior coroners in the last couple of years, I think have almost all been women. Yes. Yes, please.
Mine is concerning on evidence and how the use of bodily tissue is used within the court system itself. I'm aware that children are in the room. There was a very interesting case about 5 years ago in Canada where a woman who was very brutally raped and murdered, and part of her body was actually brought into the court as part of the prosecution's defence on her reputation. How do you feel about that? Do you think that will come into the legal system here? And how would you feel about using body tissue in that way?
That in court, that would sound quite unusual. Difficult to understand why that was necessary. You'd think that any issue between pathologists would have been dealt with before it had come to court in terms of examining anything. It may well be, of course, in court there are arguments from pathologists about particular findings, but it's slightly surprising to think of a need to actually bring things into court. So I don't imagine that will happen. That must have been a fairly unusual case. Of course, the post-mortem process is very detailed, particularly in a homicide or something of that nature. You'd certainly expect all that to have been done beforehand. Yeah. And we've got a question here, I think.
If a coroner killed someone, who would find that?
That's a good question. Brilliant. Let me think. It could be the neighbouring coroner. Yes. No, I'd probably get away with it.
Stop there.
That's a good question, though. And actually, I do get quite a lot of authors write to me who are doing plots for books, and they ask me questions. Some like that, actually, asking, what would happen if this happened? It's become quite interesting. Yes.
I was really interested in the Regulation 28, the report. Have you, in your capacity as an Oxford coroner, done that in relation to military deaths? And the reason I ask that is I can't remember, my memory is not good, but there was quite a controversy in Oxford, and in fact it was sort of commonly argued by the conspiracy theorists that that's why bodies were actually going to Wootton Bassett in order to go to a soft coroner in Wiltshire, which I'm not saying I believed at all, but I mean, that controversy was about criticism of...
Yes.
So I wondered whether you'd ever used or...
Yes.
And do you feel free to use Regulation 28? Do you feel constrained?
No, not at all, completely. Things have changed, actually. I mean, going back several years, there were delays over military inquests, and given the nature of the cases at high profile, and that certainly was regrettable. And a lot was done by the then coroner and then and others to deal with that. Other coroners were brought in to help, and there were some certainly criticisms that were made in the press from the coroner's court of equipment, vehicles, that kind of thing. No, the reason actually I think the cases went to Wiltshire is just because they they closed Bryce Norton down, or the relevant part of it, for repairs, and repatriations came back to Bryce Norton from RAF Lynham once that had been done. But in direct answer to your question, no, if there is an opportunity to make a Regulation 28 report, I do so, and particularly now that it's a duty, not just a power. I can give an example of a case I did where soldiers were killed in the back of a vehicle due to an explosion. It turned out during the course of the evidence that the fuel tank was actually in the crew compartment, and that exploded, and with the obviously devastating consequences of that as well. So one recommendation I made was that there should be improved, more work to improve the safety of the tank within the crew compartment, and that work was subsequently done. Yeah. And did we have another question there?
Oh, yeah. It's gone, I'm sorry.
No problem, if it comes back, let me know. Yes.
Obviously with the mention of the Human Rights Act, do you think that the abolition of the HRA would have a significant impact on both how you do your job and what entails with your job?
I don't think it would actually, because the modern approach from coroners is to try and explore all the, within reason, all the questions that the family have. Obviously it has to be within reason, it has to be related to the cause of death. I find it difficult to answer because if we don't have the Human Rights Act, the 1998 Act, I'm not sure what, if anything, is proposed in its place. There aren't too many inquests where it's an issue at all, quite few in number, and the sort of cases where it does apply, like a death in custody or a police shooting or something of that nature, there'll be very high profile cases that will be investigated very carefully anyway. So in fact, it probably may not make a lot of difference.
Why does it take 6 months?
Quite often a lot of cases can be dealt with inside a month, 2 months, 3 months. But where you're relying on others to produce evidence, such as hospital doctors, it might be the health and safety executive, it might be the police, it might be various outside agencies. I don't have any real control over how long it takes. The other thing is, if it takes, say, 2 or 3 months to provide to finalise the inquest file, to get all of the evidence, I'm required to give advance disclosure, a copy of the inquest file, to the family at least a month before the inquest, so that they've got time to prepare and everything. So before you know it, things are condensed quite a lot. So that 6 months may sound a lot, but in fact, when you go through the processes, it's not a great deal of time. Most inquests now are less than that. Certainly straightforward inquests, maybe 3 months, 4 months, but it can take a bit of time. Yeah.
You mentioned earlier that most inquests have been recorded, and you mentioned that those recordings are available. Where does he find them? They're held by the Coroner's Office. When I say they're available, they're not available to just anyone kind of thing. They are only available to, as I explained, interested persons, so family, other interested persons that have taken part of the inquest, or anyone who needs it and has a legitimate interest, but they're not supplied just to anyone. And when they are supplied, there's normally an undertaking required that they don't suddenly appear on YouTube or wherever. Yeah. So there has to be a bit of control over it. And not least, of course, it would be distressing for the family to suddenly see a recording appear somewhere. At the back.
I don't know if it's relevant or not, but I'm quite interested about corporate manslaughter. Like the gentleman mentioned earlier, suicide, and it's about intent. So say, for example, an employee committed suicide due to bullying, but the intention wasn't to kill himself, but to kill himself. I'm not sure if it came to your office, but happened in Oxford with a young lad. He jumped in front of the train not sure if you want.
Yes, I think so. Are you saying if it's thought that there was a work-related issue or someone was stressed at work?
I know that his mother was very distressed, and she believed that the reason for his suicide was due to what was happening at work, and it caused him to have a mental illness, which he reacted in a way that he jumped in front of the train because he wore his uniform when he done it. So how would it be possible for the family to determine that it was because of animal?
Yeah, so that would be difficult, wouldn't it, actually? Because one of the things I do say at an inquest, when this is a potential suicide case, I do have to explain that what was there to determine is how who the deceased was and how, when and where he came by his death. And I say, yeah, exactly, not why. Because it would be very difficult for anyone really to know why someone's killed themselves, and least of all for a coroner who didn't even know the person, try and determine that as a factual finding. So why someone does an act isn't actually something that the coroner needs to determine. There is a related issue because the coroner has to determine that they intended to take their own life. So that almost is getting into the realms of why, but not quite. And going back to your question about an employer, I don't think, apart from a very extreme case where there would likely to be a need to get the employer there to answer questions. I mean, for example, if there's a relationship breakdown, man and wife, and the man commits suicide, you're not really going to get the wife in and examine her and kind of blame her for it, are you? And I suppose it would be almost the same in an employee-employer relationship, apart from a very extreme case where there was something really badly going on with the employer. Yes.
Yes. You mentioned about hospitals like mishaps during surgery. Have you ever convicted a doctor in that sense?
Yes. Well, one thing as a coroner you don't do is actually apportion blame or convict, if that's the right phrase. Or attribute blame to anyone, because it's a fact-finding inquiry, inquisitorial in nature. You find out what happened, you get to the bottom of the facts, but when it comes to giving your conclusion, you don't actually name anyone. So you can say a doctor did whatever and it resulted in the death, but you don't actually name them, and it's not intended that that would then go forward to a criminal case. It could be. The evidence that comes out at an inquest might be useful for a subsequent criminal case, but it's not the purpose of the inquest. I have on occasion, rarely, it's been necessary, having heard evidence from a doctor or a nurse or whoever, written to the professional body and asked them to review something. I think I've done that on a couple of occasions. But normally, in a case like that, the relevant professional bodies and regulators are already involved. Yes?
My question is very, very quick on this. So you said about local authorities. So like in London, is there a coroner per local authority? So like you have Wandsworth?
There are coroners for, I don't know how many coroners there are, and there were quite a few. And geographical areas, and it must break down into local authority areas. The size of jurisdictions varies. In Oxfordshire, as I mentioned, we deal with about 2,400 death reports. There are one or two jurisdictions that deal with as many as about 6,000. For example, Birmingham is one jurisdiction. You think it would be split up, but it's not. So that's a massive jurisdiction. Some of the London jurisdictions, 4,000 or 5,000 deaths per annum, and bigger coroner teams dealing with them. Still one senior coroner, but a bigger team of assistants underneath.
Thanks. I was interested in sort of main challenges of your job, and also you suggested one possible reform of having a team, and any other reforms. So.
Yes, biggest challenges are trying to deal with the cases expeditiously and without delay in circumstances where you don't have control over everything. You have control over certain things, but not everything. So that's a challenge. For a non-doctor coroner, it can be a challenge dealing with complicated, complex medical cases. So some medical support and advice being available nationally to coroners, I think would be useful. That was going to be part of the medical examiners scheme, but as I say, that's not come in and may never come in. In terms of other reforms, a lot of it actually has already been done from 2009 and particularly 2013 onwards in the Chief Coroner. All those things I can think of: accountability, mandatory training, consistency, family at the centre of things. That's all come in, thankfully. So I think a lot of that hard work's been done. Any other questions? Yes.
Could I just ask, because it's been bugging me for years actually, narrative verdicts, is that a verdict of itself, or is it just a way of delivering one of the, because there are a set number of verdicts on there that options. So is narrative one of them, or is that just
no, there are what's called short form verdicts, traditional verdicts, which are unlawful killing, natural causes, accident, industrial disease, suicide, alcohol and drug related deaths. They are verdicts in their own right, conclusions we should call them now, not verdicts actually according to the new legislation. So those are on one side. On the other side, our narrative is the narrative verdict, which, as the name suggests, is just a few short sentences or a few short paragraphs setting out the answers to the 4 questions: how, when and where the death occurred. And it's particularly useful if a death falls in between one of those short form verdicts. So for example, there's a death post-surgery in hospital. Is it a natural cause, or is it an accident? It could be a mix of both, kind of thing, and therefore a narrative verdict just explaining what actually did happen can stand in place of a short form verdict if it doesn't fit easily into that category. They became increasingly frequent, and that was beginning, I think, perhaps to present a problem in terms of statistics and actually determining trends like suicide and hospital-related deaths, etc., etc. And so the Chief Coroner is quite keen for them not to be used as an easy opt-out, and if it fits within one of the traditional conclusions, then to give it. If it is one of those unusual cases which needs more of a descriptive conclusion, then give a narrative. Yeah.
Do you have any advice for if anyone's been inspired to follow in your footsteps?
Well, funny enough, I've just appointed 2 new assistant coroners, interviewed about 10 days ago, and we had 2 vacancies and we had 96 applicants. So that's an awful lot of people. Now that's all solicitors and barristers from private practice and in-house and CPS, government lawyers. So a lot of applicants, and I think that's just indicative of how keen people are to maybe get away from private practice, and also even if they're not just trying to get out of private practice, we're just keen to get this kind of experience in a judicial role. So in terms of advice, it's quite tough getting the positions. Carry on studying your law. Go along to inquests or public hearings, of course, and therefore go along. You can always write to the coroner, and you can just go along to the inquest. Anyone can go, so that's a good thing to do. And if you want to have a bit of experience in with the coroner or in with the coroner's officer, most coroners will agree to that. Come in for a short while. And if you can demonstrate an interest, then that certainly improves your chances. And if you qualify as lawyers, if you can also do some kind of medical qualification as well. Obviously not. I'm not saying go as far as becoming a doctor, but there are some similar certificates in higher education that to do with forensic medicine, that kind of thing. That would really be helpful.
Yeah, I mean your job sounds extremely busy. So presumably you'd like to have a bigger team.
Well, the team's quite big now. Okay. So I already had 5 assistant coroners, including Nicholas Gardner, the previous coroner. But for various reasons, some of those my existing team were unable to sit, unable to carry out for good reasons. So they weren't able to. So hence the need to bring in 2 more. And I have actually particularly recruited someone who's got a medical background, going back to what I said about dealing with complex medical cases. So those appointments aren't in place yet, but what they say, one of them is a former nurse and a former, and then became a solicitor and has been dealing with clinical negligence work for sort of 20 years. So obviously he's very up on medical matters, so that will be useful addition to the team.
If I can ask one last question, I know I'm holding the number. I just wonder if it's kind of changed your view of life, since you've had this job.
It's funny you say that. I think it does actually. Yeah, you do realise, and particularly as you get a bit older, you realise that you're not here forever. And yeah, you do think to yourself, blimey, things can happen, most unexpected things can happen just around the corner. So it does make you think about that and reflect upon it a bit, and make sure that you make the most of the time that you've got. There we are.
Thanks very much.
Thank you for coming.
Okay, not at all. What have you got lined up in your diary for the next speaker?
We have
as a class. There's more to it. I don't know more to things. So real for the soul that I'm not lying.
You might think that we're not.